Welcome to Lawyer and Layman Explain It. This is a show where we discuss topics related to law and social justice from the perspective of a layperson who has no idea what they're talking about, but is very confident in their opinions.
And someone who can tell you what 3 LOL means. It's a thing. Before we dive into our episode, quick disclaimer. This podcast is for educational purposes only and is not intended to provide any legal advice. If you need legal advice, you might want to pause this podcast and find a lawyer.
But then please come back.
Any inaccuracies are unintentional, and facts could change at any time. Do your own research.
So before we get into the episode, I'm curious about 3 LOL. And yeah, I'm curious, what is 3 LOL?
So it's very much of the law school verbiage, I suppose. It's basically, so in your 3L year, the aim or ideal is that you're kind of coasting. You have your job after law school lined up. And I will be clear, this is not always true. You know, some people are coasting, some people are still lining things up, and there's no wrong way to go about it. But in theory, it's sort of like the senior year syndrome. Like you're in 3L, you're like, oh, I've done this grueling thing.
Yeah, senioritis is what they call it. Huh?
Exactly. Yes.
Yeah, I figured it was probably like something to do with, because there's 3, it takes typically full-time students 3 years to get through law school. So right. I figured it was something with that.
Yes. And the LOL is just like, you're taking the electives, the fun stuff. Very, senioritis.
Total vibes right there. Like, 3 LOL, you're just LOLing in the world.
Exactly right. Thank you for clarifying, because in this podcast, since we aim to explain it and we want to break down things that may not be familiar to non-law people, non-law school student people, that's a great question. So thank you for asking, Martin. So in the last couple episodes, we shared some basics and fun facts about the Supreme Court of the United States.
And if you haven't, go back and take a listen and catch up.
We didn't want to start with the history because history can be boring to some people. Although both of us are history buffs, BT dub, so that doesn't apply to us. Today, though, we're going to turn your brains to mush with some history about the Supreme Court.
Yay.
Martin, be honest with our listeners. How boring do you think this episode will be?
Geez, I don't know. That's a layered question there. I feel like our target audience might be interested. If you are a law nerd or lawyer or interested in law, maybe they'll be interested. But yeah, Supreme Court sounds super boring. Oh my God. Old people and courtrooms, like that sounds as boring as it gets. And then the history about that, oh man. It sounds on its face like it could be very boring. However, I'm really excited for it.
These are all fair points, and I'm glad you're excited because I think we have some interesting stuff that even I ran across, and I was like, I would like to discuss this with Mark. All right, so listeners, bear with us because this episode is fundamental for our next conversation about the modern Supreme Court. And as Martin pointed out, we're going to have listeners that are lawyers or who know a lot about this topic. If you fall into those categories or you're otherwise Supreme Court nerds, we invite you to reach out to us and let us know what we missed. Let us know if we got something wrong. All right, so we're diving in. It all starts with the Constitution. Martin, we had a brief discussion before we started recording, and so I think I know the answer to this question, but please tell me you have your pocket Constitution with you.
I do not, as you know, but I feel like that's so appropriate for a layman. As usual, I did zero prep for this episode, so I think it's just accurate that I don't. But luckily, as a layman, and we all have Wikipedia, so what am I looking up?
I would like the record to reflect that I did send Martin an outline of some topics and things to.
Hey, now when was this outline?
Correct. I sent it to you mere moments before we started recording. But I will ask the record to reflect that there are all caps that say you will need your pocket Constitution at the top. But it's all good because I literally just told you about the existence of this document.
I do see in all caps you will need your pocket Constitution. Yes. In my defense, I was halfway to a nap with and cuddling up with our puppy. So I miss some things.
And in your second defense, I sent you this again mere moments ago. But also, all these things we're going to talk about are literally on the internet, so we're all good here. So it's all good, no pocket constitution. But question for you: which part of the Constitution established the Supreme Court? We talked about this a little bit in our past episodes with the Supreme Court 101.
Okay, so that's interesting. I think we'll go ahead and do a quick live Wikipedia search. As a layman, I don't know if I would, given the framing, if I would start with Wikipediaing the Constitution or the Supreme Court. And I think, well, what I did do is go to the Supreme Court Wikipedia page. So according to Wikipedia, it looks like the framers' Constitution had debated division of powers between legislative and executive departments. And there were delegates to the 1787 Constitutional Convention that established the parameters for a national judiciary. But I don't see where it says in the Constitution.
That's all good. And we also recorded our prior Supreme Court episodes a while ago. So I will throw you the bone here. It is Article 3 of the Constitution that establishes the Supreme Court.
Ah, yes.
Can you remind us of that language in Article 3 that establishes the Supreme Court? And I do have this in your outline, so you don't have to look it up.
Thank goodness. Article 3 says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as a Congress may from time to time ordain and establish. And for the readers, I'd like to point out one Supreme Court is not capitalized. Court is, but Supreme Court is not, which I find interesting.
That's a good little spot. Good shout out. I think as we look at more historic writing, use of capitalization has so fluctuated. We almost could do an episode on that, like spellings and capitalizations and emphasis and what that all means. But very good point, Martin. Thank you.
Being a word nerd too, I guess, like a grammar nerd. That's just interesting to me because I think capitalization, like and a layman nowadays, I would think Supreme Court, you capitalize that because it is a proper noun. However, it's interesting that the framers didn't capitalize it. Like as a layman, I would have thought in the Constitution it would say the Supreme Court, da 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 da. But no, it was actually. It's just interesting how language evolves and how they used it at the time and how the reality has evolved into we see this thing as Supreme Court, capital S, capital C. But back then they're like, well, we should just have one Supreme Court.
Sloppy drafting. Or you're right. I mean, things have just evolved to there was a concept and a notion that was put in a constitution and also was like, but we're going to leave this for Congress to decide because we're not really ready to hash all that out yet. But it also took time and history and iterations to get to this grand Supreme Court that we have today. But you brought up the Constitutional Convention, so I want to flash back to that time. And we'll set aside that I would have been property back then. It's all good.
Ooh.
Martin, history class pop quiz. In addition to what you read on Wikipedia, what do you remember about the Constitutional Convention?
Gosh, that was a long time ago back in elementary school. I mean, we might have talked about it in middle school and high school probably too, but not, not like that. I mean, I can think of the founders that were there and who took part in writing the Constitution: Jefferson, Benjamin Franklin, John Adams. And honestly, the first thing that comes to mind was that John Hancock signed it very largely, I think, right? And was the first to sign the Constitution. So I imagine he was there at the convention. But yeah, that's all I could think of off the top of my head.
So respect and props for naming names. Okay. That's fantastic. The size of the signature. That's unlocking memory. And I feel like I also remember that. I would need to verify. But that does sound right. But you are correct that a number of these old-timey dudes got together to talk about this stuff, and I'll give you some more context. Alright, so Martin, picture this. It's the late 1780s. The founding fathers, also known as the framers, stanking to high heaven with the combination of bad wigs, layers of clothing, no air conditioning, and it being summer in humid Philadelphia. Met to gripe about the fragmented form of government where states were doing their own thing for the most part. And so they wanted to come up with more structure. In addition to the various concessions that allowed Southern slave owners to continue to buy and sell human beings, as long as they kept that ish in the South, the convention resulted in the formation of our three branches of government, which are kicking it back to you for civics class.
We're going executive, that's president, legislative, Supreme Court, which we're talking about today, and then legislative, which is Congress.
Excellent. And the judiciary was established by Article 3, which Martin so kindly read for us. So are you with me so far as to kind of this context of what was happening during Constitutional Convention times?
Yeah, it all sounds familiar. I see on Wikipedia it was in Philadelphia, which is interesting.
Yes.
That was one of the original like large cities in America, right? Isn't it often, is it referred to as a second city? I feel like that's a nickname. Anyway.
There is a nickname that is going to come up very shortly. Second City. I don't remember that one, but you are the guru here. So layperson, look it up for us.
It looks like it was Chicago. And I remember that because I was like Alex Trebek levels of shade.
I was thinking Ken from Jeopardy, so yes, very, very similar.
Ooh. Oh, it cut deep. No points. I was gonna say I remember that because in high school football, we use cities as nomenclature for what snap count we're going to use, and clearly I would have gone on the wrong count. But apparently, if we would have yelled Chicago, it meant we're going on 2 because this is the second city. That has nothing to do with the Constitutional Convention.
All good, because listeners are getting a chance to learn more about Martin and his love of football, which will definitely come up in some later episodes. So when we're on tangents anyway, and I have another one for you. Martin, I am not just making up this point that the founding fathers smelled like unwashed armpit. Can you please read for us this text from the National Archives website that gives us a little bit of insight to the setting at the time of the Constitutional Convention?
Before I read, I'm really interested how you set that up with, yeah, these folks really stink. And then can you read something from the National Archives? So here we go. For the next few days, the air in the city of brotherly love, although insufferably muggy and swarming with blue bottle flies, had the clean scent of conciliation.
Now, I know the archives people were not like, my guy, Hamilton and Franklin, etc., smelled just bananas, gross, nasty. That's not what they said. But they made it clear that there's this distinction of clean scent of conciliation, hyperbole and metaphor that it is, obviously contrasting with how bad these guys smelled. I mean, like, that seems very clear to me.
Yeah, that was definitely some shade being thrown there.
Right? I had to point that out. It was completely not necessary for our dialogue today, but I just had to point it out. Also, I won't say this as a tangent because it's more important than how the framer smelled, but it was at this moment, this Constitutional Convention moment, that my ancestors, I should say, each became 3/5 of a person because, negotiation.
That's a whole topic for a whole other episode too, and the implications. Yeah, that's pretty crazy.
Yeah. So we are back on track. Even though the Constitution established federal courts, again, Martin pointed out, Article 3, details of the Supreme Court were hazy until the Judiciary Act of 1789. Martin, do you know anything about that act?
No. Zilch. Zero.
This is perfect. This is why you give us the layperson's point of view. The National Archives website considers this a milestone document, and I'm going to ask you, Martin, to read for our listeners what the archive says about the act.
One of the first acts of the new Congress was to establish a federal court system through the Judiciary Act signed by President Washington on September 24, 1789. The founders of the new nation believed that the establishment of a national judiciary was one of their most important tasks. The generality of Article 3 of the Constitution raised questions that Congress had to address in the Judiciary Act of 1789.
So, Martin, what do you think this means? Why did we need this congressional act when we already had Article 3 establishing courts, federal courts?
This seems like something that we've an idea or recurring theme. I hate that I say that so many times, but alas, here we are. A recurring theme of the Constitution or some law being codified and should, have meaning and bear teeth. However, here they're very clearly calling out that it was too general, and we need specific. We need details. We need the nuts and bolts. Like, yeah, we should have one quote Supreme Court, but it looks like this is saying, what does that mean?
So you're right on a few fronts. First of all, law is often recurring themes until someone's like, is there a good reason we're doing this recurring theme / it's oppressing people? And then things change. Sometimes, maybe. But you're also bringing up the point that we often start from a place of generality. A language can be in the Constitution or a law can be passed, but then there is this idea that someone else needs to do the work and figure it out. I mean, that's ultimately what happened with Article 3. Like, Congress, can you just put some details around this? We don't really know where we're going with this yet. Which, to be fair, this was an entirely new structure and system of government that they were building from scratch. So it does make sense.
Yeah, this was 1789. So America just recently declared independence. They had won the Civil War, or they had won the Revolutionary War, and they're putting together their stuff. And it was one of the first true democracies, at least in the modern sense, right?
Right.
So that makes sense that they kind of kicked the can down the road a little bit and said, we'd like to do this. Hey, future generations, you figure out the details.
And even future people who were tasked with different pieces of implementing this new constitutional and federal structure. Because at the same time, sort of, the judiciary, executive, and legislative were becoming branches. And so this notion that the Constitution says Congress is going to establish something, well, now we even have to come up with this Congress body, and what's that going to look like, and how do they make things happen? And so a lot of that, when you think about it, and how there were so many people trying to come together and nail down what government was going to look like, happened somewhat fast. I mean, we had the Judiciary Act come about and kind of set forth, we're going to have lower federal courts that do some of the work, and the Supreme Court will be the higher one. And we start to get a little bit more clarity, again, relatively quickly, given how new the government was.
Yeah, that's wild. I mean, 12 years to have these sweeping changes, and not just sweeping changes, but building something from scratch and making it all work together. Much less in the time of mail being delivered by horse-drawn carriage, or Paul Revere riding through the streets on his horse yelling. Yeah, that does seem extremely fast for such a monumental task.
Yeah.
It's also interesting that, back then there were all these different personalities, but somehow they were able to work together and make it work. Yeah, it's fascinating.
File away the horse-drawn carriage. That will come back. But all valid points. So we are talking about the concept of courts, federal courts, the Supreme Court, and then lower federal courts. But as we know, a court needs judges, right? So we'll now talk about the dudes that were on the first Supreme Court. Martin, I will give you and I left a placeholder to look around and find an item of value. I will give you my gavel. So this is pretty serious.
That is
if
really
you can
serious.
name one person on the first Supreme Court, and you can't cheat. So do not look up anything in your vast access to knowledge that is the internet.
Um, if I lean down, I can read the names I
No,
of the
don't
sheet
peek.
because there's zero chance that I would name justice on the very first Supreme Court. Okay, if I was going to give a guess, I'm just going to go with what first came into my mind, and I think while this name is fitting of the era, uh, it's also very generic, and there probably might be somebody with this name around today, but Jonathan Adams is what I would guess. I feel like that's very founder. Jonathan might not be, but Adams. I feel like there's a lot of Adamses.
I need listeners to know that the overwhelming sense of relief that I feel that I don't have to part with my gavel because Martin is not correct. And I'm going to read some language from the Supreme Court's FAQ document. As stipulated by the Judiciary Act of 1789, there was one Chief Justice, John Jay, and 5 Associate Justices who were named James Wilson, William Cushing, John Blair, John Rutledge, and James Iredell. No Adams among them, unfortunately. So that is 6 people if listeners are playing along with the math at home. And a bit later, we'll talk about how we got to the current number of 9. All right. So, Martin, sometimes you got to take the L's where they come, but redeeming chance. I'd like you to look at.
Why are you so focused on me rubbing in? You're really bringing the heat this episode.
And actually, I mean, before looking this up, I could not name. Well, okay. I knew one of the names in isolation, but I did not know that he was on the first Supreme Court. So I am in the same position as you and probably many of our listeners who could not name someone on the first Supreme Court. So I take back what I said about L's and dubs. But an activity that we can do together is look at this picture of these guys. And I want you to just give me your reactions. And, you can tell me about the obvious because it's the 1790s, so all these dudes are white. But, you don't have to go for the low-hanging fruit. Just take a look and let me know your impression.
Okay, let's see here. Wow. I need the audience to know these are like paintings, it looks like, and drawings. You could probably imagine what the paintings and drawings look like. They kind of look like some of these out of textbooks. Are we going like one by one, or what's the protocol?
Just tell me what you think. Like, how would you describe what you're seeing? Anything you see that's in common among them? Anything that stands out?
I mean, yes, there's the obvious things, but I kind of do want to go one by one, like this first guy. Oh my gosh, what? Wait for any listeners to see this because I'm trying to think of a safe way that I could describe this person and frankly insult them because he's not too good looking of a guy according to this portrait, and he's got kind of a weird smirk. Gosh, they all look like the Undertaker has seen them. Like they're all just pasty pale white, kind of old, strange looking guys. But I guess that was most of the founders.
Right. I mean, I'm with you, Martin, and I will be honest. I have seen the historical drawings and portraits of the folks like Benjamin Franklin or the ones that we know better, George Washington, etc. You could maybe replace one of these guys for them, and I would be like, oh yeah, that's Benjamin Franklin, maybe. Yeah. I mean, there's just this sort of generic portraiture of the 18th century look. So
yeah, the guy in the lower left-hand corner, you could show me that picture and say that was an artist rendering of Ben Franklin, and maybe even the guy in the bottom on the middle. Kind of digging the captain hat in the top right.
It is a pretty snazzy hat.
And the bottom right, if you would have showed me that and said that's George Washington, I'd be like, yeah, that's
same, 100%, 100%.
I can't. It's also interesting because they are drawings and paintings. You might get a little, audience when you see these. You might get a little taste of how the artist felt about these people, because who knows what they actually really look like.
Right. Well, thank you, Martin. I appreciate you giving these descriptions
I
and
I
reactions.
I really really want to dunk on some of these people, and I'm curious, audience, what kind of dunks will you come up with for these guys? Because they look very dunkable, but I'm trying to not be too mean. Honestly, I think I am, ironically, but yeah, you can move on.
Eh, these are very valid reactions, so thank you for them. Question for you, and maybe it's somewhat clear from the images and maybe not. Do you think they wore wigs on the first court?
Yeah, that seems such like a founding of America type thing. Despite rebelling against the British, we for some reason we like those white powdered wigs.
So that sounds right. And can you read some language we have documented about at least one of these guys and their wig?
Spectators at early sessions admired, quote, the elegance, gravity, and neatness of Justice's robes when Cushing walked along New York streets in the full bottom professional wig of an English judge. Little boys trailed after him, and a sailor called, my, what a wig! Cushing never wore it again. God, what sort of fanfic? Like, what? Who was writing this? Like,
the fact that this is documented for us now to read hundreds of years later is, to me, hilarious. Also, it had to feel so good to get those wigs off because it just took the one person to be like, bruh, you look just bonkers. And they're like, yeah, I'm kind of hot and uncomfortable in this wig anyway, so I'm gonna let it go.
I feel like I don't know if this was like from the internet or something, but I feel like one of those like what we didn't learn in school things like weren't those wigs like infested with lice or something, or wasn't there something to do with lice in the wigs? Maybe the wigs were thought to prevent them, but I don't see how that. I don't know.
Yeah, you're unlocking another memory. There, I feel like there was study of like the hygiene of the wigs, and there that came up. That also tracks for what I remember learning in elementary school. Which, I mean, not everything sticks in your head when you're like 7, but dirty wigs does. In any event, I'm picturing the judges being like Willow Smith and whipping their hair back and forth with
Oh my
freedom after
god.
they take their wigs off. And mostly I put that in there because we need a music reference every episode. Okay, so that's why that's there, Mark. So we've looked at images of these guys, but do you know or have any guesses as to how they were picked to be on the court?
It's crazy because I mean, in this time, like they were first establishing this stuff, so I imagine, um, like the founders, whoever the representatives was, the folks who were signing the Declaration of Independence or the signing the Constitution. I imagine they were probably voting, and just because the founders built in some of these things that I think are actually kind of smart, and sometimes I guess, I bet you it was like 2/3 majority of some voting of the representatives or something like that.
Excellent guess, especially given what we kind of knew about the process taking shape at the time.
Oh, and also probably nominated. I was going to say by president because that's what it is currently, but I'm curious back then because things were so new. Like, would they have trusted one person to kind of start the process? I don't know.
You are getting much warmer, my friend. So, George Washington, being the president after the Constitution took effect, appointed these gentlemen to the court. And not only that, he appointed all the federal judges to all of the lower court positions established by the Judiciary Act as well. So, yes, we decided one guy should be in charge of having this much power and telling all these people to be judges.
That's wild. That's interesting. And obviously, when you look back at the legacy of George Washington, I think one of the biggest parts of his legacy was that he wanted to ensure that he did not become a king because that was the whole point of America, right? So it's interesting because at the same time, these people were so distrustful of monarchy, and yet they would prop up individuals with all this power. And luckily, for what, a couple hundred years or so, there hasn't been one person who's wanted to consolidate power and been able to.
So I appreciate you sharing that sort of insight into George Washington because this information about George Washington appointing these folks to the court I pulled from a historical website, the mountvernon.org website that's devoted to kind of keeping Washington history. And so, for curious listeners, we'll share a link to that website that has a lot of history about George Washington, including the judges he appointed. I will note, though, that the site takes a, how should I say it, charitable position on his views of slavery, but that's a topic for a different day. Okay, Martin, in
And
our
where else was he going to get his dentures? All right. Moving on.
in our Supreme Court 101 episodes, we talked about the address of the current Supreme Court building in Washington, D.C. But of course, that building didn't always exist. And the first Supreme Court didn't have their own building, so they had to come up with a place to meet. Martin, do you recall ever learning in history class when or where the first Supreme Court met?
Ooh, I don't think I ever learned that.
That's fair. I don't know that I learned it in school either. I may have only learned it just over the course of researching for our podcast. But can you read this language from the Supreme Court's FAQ page?
The first meeting of the court was scheduled to take place in New York City on Monday, February 1, 1790. But the lack of a quorum, parentheses, only 3 of the 6 justices were present, in parentheses, delayed the official opening until the following day, Tuesday, February 2, 1790.
So, any thoughts on what you just read?
I mean, New York makes sense. Like, that was like the first city, and it was a big city, and it's probably where most things happened back then. It's interesting there's a lack of a quorum. Like, how serious like, do these justices take this job seriously? Like, I mean, I guess they were still figuring it out, right? And like, what was Washington going to do if they didn't show up? So clearly they had more important things to do than conduct the very first meeting of the Supreme Court.
I mean, it wasn't capital S Supreme Court, it was lowercase s. So maybe they were like, oh, this is optional. Also, hey, you know what? Who knows if they were like, hello, Tuesdays are my hunting day. Let's pick back up tomorrow. Yeah. And I don't know why they have the accent. I mean, maybe they do, maybe they don't. But anyway, yeah, it is interesting, the lack of quorum piece. Martin, can you also read this language that describes the exact place where the Supreme Court met?
The court met in New York City at the Exchange Building, also known as the Royal Exchange or the Merchants Exchange. The Exchange Building sounds like kind of familiar. Is that like a financial district, historical building or something like that?
So I had that exact same thought, and I had to look into it. This particular Royal Exchange Merchants Exchange does not still exist. It was very much like a place where merchants came and went, and it was not a suitable place for the Supreme Court. Hence, them ultimately deciding to relocate from there. But there are still various stock exchange and other buildings that I imagine that the structure and just kind of how important buildings were created and named stuck around a lot in New York. But yeah, the name stood out to me too. I was like, huh, this looks like something we still have. But this exact building is not something that still exists. And yeah, you hit the nail right on the head that New York was the capital at the time. The court ultimately ended up relocating to Philadelphia, which we've talked about, still a pretty important city. But yes, New York City was not a place where the Supreme Court was for very long. Now we'll talk a bit about what the first court did once they finally got their attendance together. Martin, would you be surprised to know that the early Supreme Court didn't really do that much official judge stuff for the first few years?
Yeah, I guess not. I mean, as we kind of set up, like everyone was still trying to figure out what it meant, what America meant, what it meant to operate and function as a new country.
Yeah, that's an astute observation. That sounds right on.
That is, I guess, also a little bit surprising because if you didn't know what you're doing, like if you didn't quite know the role that you played, wouldn't you fall back on the things that you feel comfortable with? And I feel like, I don't know, judges would just be like, yep, let me sit in court. Like that seems like, I don't know. That seems like the basic function, but I guess, do they even do that nowadays?
Excellent question. And we will talk more about that. But to your point of is there something that they at least can do from I think I should be sitting here and doing this perspective? Can you read this text from the Supreme Court Historical Society?
Required by law to sit twice a year, it began its first term with a crowded courtroom and an empty docket. Appeals from lower tribunals came slowly. For its first 3 years, the court had almost no business at all. So I guess that makes sense, right? It was kind of set up as this appeals court, and I think if I remember correctly, also, the Supreme Court over interstate issues. Like those are kind of the two like areas of jurisdiction the court had, and makes it like appeals take a while. Like there would have to be court cases, and they'd have to be some back and forth before they could review the appeal. And then also, the states are probably not mature enough to really take official legal action against each other, or they figured out how to handle that elseways without the Supreme Court. So I guess it kind of makes sense.
Yeah, I agree. I mean, I think it probably became clear fairly early on that they needed to sit there because there was this whole come together twice a year requirement. But yeah, they may have been doodling or planning for their next hunt or doing whatever people did in the 1800s, and just knowing that they formally had to be there, but not having much to actually do.
It's also like, I mean, I kind of brushed over that, but twice a year. You meet twice a year? That's it? That's not a bad job.
Twice a year for a period of time, though, right? Like kind of similar to the terms that our current Supreme Court still has.
I got you. Yeah, still not a bad gig. It also kind of, I think, gives insight into what the founders anticipated their role was going to be. Like, if you just have to sit for a certain period of time twice a year, sounded like they were really, I mean, what you think a judge would be is kind of this oversight, like the ultimate decision maker of yes, no.
That's right. And trying to figure out what that ultimate decision making should look like. I think they were still sussing that out. But to your point of this being maybe a cushy gig, maybe not. Do you know what the first justice's biggest gripe was?
Real quick, I do want to say they were pretty sus. I will say that. They remain pretty sus to this day. They might be sussing it out currently.
I see what you did there. Nice.
Okay, I'm sorry. Your question was
what the first justice's biggest gripe was.
That he had to work 2 days a year. No, for longer than 2. Okay.
Do you remember earlier in the episode when I said something's going to come back later in the episode? File this away.
Gosh, I thought there were. Oh man, I thought there were a couple things.
A method of transportation.
Oh, his biggest gripe was getting to Philadelphia.
Very close, very close. So the Supreme Court was expected to travel, and this was not by yacht or first class flight like or some
RV.
Right. So when they were, yes, not the luxurious RVs that we, not personally, but conceptually know and love. So twice a year, the members of the Supreme Court had to travel by horse-drawn stagecoach to serve as circuit court, and this was known as riding circuit. Sometimes it took them 19 hours to get to where they needed to go. And at one point after John Jay threatened to resign, Congress scaled the requirement back to 1 circuit travel a year. Martin, what are your thoughts on this? I mean, how do you think our current Supreme Court would fare if they had to travel across the country like this and decide cases?
By horse-drawn carriage, it would be a struggle, especially given the makeup of a court. There's some old guys on there, but given that technology advances, I think maybe a couple of justices might have a few more RVs. There'd be some more private jets being taken. Yeah, that's interesting. I do want to point out it's interesting that it was called riding the circuit, and it's just cool. It's interesting to me how the language evolves, and now that becomes a thing. But the etymology is from when they literally were riding to a different circuit court.
And now we have the sort of embedded circuit structure. So the various circuits, that's the intermediate level of federal court. So the first level is the district court, and then second level is the blank circuit. So we are in the 9th Circuit, being on the west coast of the country. So now you sort of see how the gaps and the blanks were filled in, right? So rather than the judges having to go from New York City to Oregon, which at the time probably not exactly what they were doing, but now they're the embedded circuits that then the appeals process through there, and then if something gets appealed up to the Supreme Court and they accept according to the process we talked about, only then does the Supreme Court hear a case, other than its original jurisdiction that we also talked about that goes straight to them.
Yeah, that makes sense. Yeah, and that is fascinating how, like, again, the language kind of determines what we call things, and it's just always interesting to kind of dive into when some of the language is probably more literal from its sources. Also, yeah, if the court had to travel to Oregon back then, they'd probably die of dysentery or whatever else Oregon Trail issues they run into.
I love the Oregon Trail pitch. And also, listeners, if you are on the East Coast, you call it Oregon, we're still going to accept your listening because we need the listeners, but it's not Oregon. Okay, I just need to clear that up. But thank you, Martin, for the Oregon Trail pitch. There was like a revival, wasn't there, recently? Like an Oregon Trail game revival, like in recent years. I didn't play it, but I thought that came back around.
I don't know. I wouldn't be surprised. Nostalgia's huge nowadays, so
you got to get your cows, your victuals, all your supplies.
It's that generation, for sure.
So, Martin, we can't forget to address the important question of how we started with 6 justices and now we have 9 on the Supreme Court. Can you read this language from the Supreme Court's official website?
Over the years, Congress has passed various acts to change this number, fluctuating from a low of 5 to a high of 10. The Judiciary Act of 1869 fixed the number of justices at 9, and no subsequent change to the number of justices has occurred.
How do you feel about the number? Do you think that 9 is right? I know we've talked about that a little bit briefly, but now that you have more context, I'm curious what you think.
To my knowledge, the 9 was mirroring the 9 circuits of appeals courts. Is that right?
This feels like something I should know, and yet I'm at a loss of words right now.
No, so to my knowledge, there were 9 justices, and like they expanded as the population expanded and their jurisdiction expanded, and I thought it was 9 judges to mirror at the time 9 like appeals circuits or 9 other corresponding courts, which gave the Supreme Court the manpower, an estimated manpower to handle this volume of cases from those courts. But I'm curious, like, why did they choose 6 and why did they expand up to 9? I could probably make a guess as to why they went to a low of 5 and a high of 10, although the high of 10 is kind of interesting.
That it being an even number too seems like ripe for difficult
decision
making.
Even with the odd number, sometimes it's those 5-4 decisions,
right?
As we talked about in past episodes.
So a very quick skim of the internet seems to perhaps corroborate what Martin is saying. Again, I'm admitting that I should have come prepared for this question. It's a good one. But I do think looking into the Judiciary Act of 1869 could provide us further illumination. And we'll link to that so that our listeners have more context on what that was, because that was the congressional act that solidified us at 9.
And then, just further in my opinion on that, like, I think we hear that the Supreme Court, they're very selective in the cases that they see. And nowadays it's really political in terms of what cases are brought before the justices and what they choose to address. But I think often we hear, the court is overloaded, and given that it expanded to 9 in, what was it, 1869? Yeah, it fixed the number of justices at 9. Oh my gosh, like that was so long. How has it not changed? Like 2 centuries. Like we have removed an entire century from when it was last changed, and yet here we are. We're still with 9. I just don't understand how that makes any sense.
It's interesting you say that, because it is not for lack of effort. There have been a number of folks in various spaces and organizations on both sides of the political spectrum that have advocated for that number to be changed. And there's a lot of that happening especially now. So I agree with you that it is an interesting observation of, for as much as things have changed, and even for how interconnected to the world our country has become in these centuries since that 1869 Judiciary Act, how is it that we only have the 9 judges? How are we still there? And what would it take? Not to say that we're necessarily advocating for it, but what would it take to change that number? Interesting questions for sure.
Whether or not we add more justices to the court is a really big question, and I'm not sure my brain can handle that.
Yeah, I mean, I completely agree. Speaking of tired brains, why don't we just call this a wrap for today? This is going to have to be a multi-part episode. We have a lot more ground to cover.
Sounds good to me. I think we could all use a break.
Martin, you want to close us out and tell our listeners where to find us?
Sure thing. Thanks, everyone, for tuning in. Be sure to catch the next episode, which will be part 2 on Supreme Court history. In the meantime, check us out at Lawyer and Layman Pod on Instagram and Lawyer and Layman on Threads, YouTube, and TikTok. If you like what you hear, please rate our podcast and subscribe. Let us know if there are any topics you'd like us to explain. Don't walk around not knowing.